I'm John McLeese, and this is Bold Radio. Sometimes in life, you just need some good advice. No one is an expert at absolutely everything. That's why we're proud to present the Bold Radio Expert Series, where we welcome a qualified and experienced individual to offer sound advice on an aspect of running a business. Our guest today is a highly qualified legal expert. We're very pleased to be joined by Dan Ransom, associate at Winnipeg law firm Taylor McCaffrey LLP. Dan will bring his expertise today on the subject of shareholder agreements. A handshake can be the start of a wonderful thing. But when two or more parties want to go into business together, you need something more concrete than a verbal agreement. Circumstances and relationships can change over time. Shareholder agreements are meant to protect all parties involved. Dan, welcome to the program.
Thank you for having me.
It's great to have you. What is a shareholders agreement and what is its purpose in business?
Well, as the name suggests, a shareholders agreement is simply an agreement among the shareholders of a corporation. We often distinguish between a shareholders agreement and what is called a unanimous shareholders agreement. Because of our limited time today, I want to focus on unanimous shareholders agreements, which are a creature of statute. And by that I mean, at the common law, it is not allowed for shareholders to agree amongst themselves to limit the ability of the directors to manage the corporation. But now we have modern corporate statutes which allow the shareholders to agree unanimously to take some of what is normally the job of the directors, so daily management of the company, borrowing money, giving security on assets of the corporation, hiring, firing, those sorts of things, taking some of that and limiting the director's ability to make those decisions and giving that authority to the shareholders. So that is a unanimous shareholders agreement. And its main purposes are, as discussed, the management of the corporation, so setting out the rules that are going to govern how the corporation is run. And secondly, dealing with what are ownership issues or ownership control issues. In other words, it deals with situations where, for one reason or another, the shareholders may be unwilling or unable to continue as business partners and need to go their separate ways. Now, that can happen for various reasons that may be voluntary or involuntary and may involve third parties. So some of the more common scenarios are the death of a shareholder, disability, bankruptcy, insolvency, marital breakdown of a shareholder, a retirement, and we all want out at some point, and of course shareholder disputes. So each one of those has unique considerations, which we probably don't have time to get into today. But just to take one, for example, we can talk about the death of a shareholder. So in the absence of a shareholders agreement, on the death of a shareholder, those shares would likely end up in the hands of either the spouse of the shareholder or perhaps the kids or maybe even some other third party.
That individual's estate.
Correct. And the chances are when the parties sat down at the outset to run this business, they weren't thinking they were going to go into business with this person's estate or his spouse or his kids or whoever. They were in business with him. And so often in a shareholders agreement, there will be provisions to deal with the death of a shareholder. And there'll often be a right for both the corporation or the remaining shareholders to buy those shares at fair market value. And conversely, the family of the deceased shareholder may want to get their money out as well. And so they'll usually have a right to force the corporation or the shareholders to buy those out.
So that's a great example. Now, let's say our listeners that are listening to us today on this expert series, by the way, Dan Ransom is the associate at the Winnipeg law firm Taylor McCaffrey LLP. We're listening to Bold Radio Experts. I'm starting a new business with a new partner, or I'm in a small business. I'm a current owner, and I'm looking to take on a new partner. Should I consider a unanimous shareholders agreement?
Absolutely, you should consider it. And frankly, it's almost always advisable to have a shareholders agreement, whether unanimous or otherwise. The reason being, at the beginning of a business relationship, the chances are there's a very positive frame of mind. The parties are not necessarily thinking about things that could go wrong down the road. They're embarking on an exciting business venture, and maybe they think it won't happen to us, or they just don't turn their minds to it. But it's important that the rules are set out at the outset when people are on friendly terms to say, look, if things go badly or if A, B, or C happens, here's how things are going to go. And you set those rules out at the beginning in a shareholders agreement so that when those things do happen, or if they do happen, then you've got clear guidance.
On the breakup.
Exactly.
You got clear guidance, so you know exactly how it is. It takes the emotion out of it, too.
Right.
I would imagine. So, let's say in the example you mentioned, when a dispute arises between two 50-50 shareholders who are both working in the business, what are some of the ways that sort of issue can be resolved using a unanimous shareholders agreement?
So in the classic scenario, which you're referring to, you've got two business partners, 50-50 decision-making power. So if they can't agree on something, then you've got a deadlock, and the company is essentially at a standstill. And that can get to a point where one shareholder or another may just decide, look, I can't continue like this. I need to get out, or you need to get out. And in the absence of a shareholders agreement, that can be a real expensive process if the parties are not in agreement on how it should happen. So one of the simple mechanisms that we use in shareholders agreements that deals with that is a simple buy-sell provision, which is sometimes referred to as a shotgun clause. And what that means is, if I'm the shareholder who's thrown up my hands and said, I've had enough, I'm going to give you, the other shareholder, two offers, one being an offer to purchase all of your shares at a certain price, and the other being an offer to sell you all of my shares at the same price. Then you, as the other shareholder, have a decision to make. Are you going to be a buyer or a seller? And if the parties have equal financial resources, then it's a fairly equitable way of resolving things. And it usually results in a fair price because of the risk involved to the person who's triggering the shotgun, because they don't know whether they're going to be a buyer or a seller. So they don't want to set the price too low because they may end up having to sell at that price.
So there's lots to talk about on unanimous shareholders agreement, a very good idea if you're starting a company and taking on a partner. The expert in studio is Dan Ransom. He is with Taylor McCaffrey LLP. You can contact Taylor McCaffrey via the web if you want to get some more information. Dan, thanks very much for joining.